Thank you, Mr. President. I rise to express my disappointment in the recent United States Supreme Court decision to curtail the Clean Water Act, the principal law governing pollution control and water qualities of our nation's waterways. The narrow interpretation now supported by the highest court will remove Clean Water Act protection for the majority of wetlands in the United States. Let me just repeat that. Wetlands, we all know how important that is to water quality in America. We know that wetlands act as the sponge for runoff. It traps pollution that otherwise would end up in our waterways and is critically important to our habitat. This narrow interpretation will remove protection for a majority of wetlands in the United States. At a time of rightly intense attention to avoiding the default crisis, this attack on clean water protection must not escape notice. This past weekend, we honored the sacrifices of our military service members. Often these celebrations of the lives and legacies of our fallen soldiers and their loved ones take place outside in community green spaces. Our parks need clean water. The Sackett versus EPA decision is detrimental to national parks, where 2/3 of the park waters are already impaired, with much of this pollution linked to out-of-park upstream activities. Under the Sackett decision issued on May 25th of this year, a slim majority of the court, led by Justice Alito, incorrectly concluded that the Clean Water Act extends only to wetlands that have a continuous surface connection with waters of the United States. This result does not mean the court unanimously endorsed this new test. In fact, this decision was, to put it mildly, complicated. Justice Thomas filed a concurring opinion in which Justice Gorsuch joined. Justice Kagan filed an opinion concurring in the judgment in which Justices Sotomayor and Jackson joined. Justice Kavanaugh filed an opinion concurring in the judgment in which Justices Sotomayor, Kagan, and Jackson joined. Put another way, 4 members of the Supreme Court, Justices Sotomayor, Kagan, Kavanaugh, and Brown Jackson, agreed that the Clean Water Act does not apply to the wetlands of the Sackett property, but they disagreed with the majority reasoning. In an opinion joined by 3 justices, Justice Kavanaugh contended that by narrowing the Act's coverage of wetlands to only adjoining wetlands, the court new test will leave some long-regulated adjacent wetlands no longer covered by the Clean Water Act, with significant repercussions for the water quality and flood controls throughout the United States. Justice Kavanaugh specifically noted that the health of the Chesapeake Bay would be at risk under the court's new test. Our national treasure, the largest estuary in the country, was one of 2 examples given, along with efforts to control flooding along the Mississippi River. In its opinion, the majority claims that Clean Water Act repeatedly uses waters in contexts that confirm that the term refers to bodies of open water. Despite this convenient fallacy, the waters of the bay are by no means limited to open waters. In fact, the Chesapeake Bay receives half of its water from a network of 110,000 streams and 1.7 million acres of wetland, most of which are non-navigable tributaries and non-tidal wetlands that drain to those tributaries. The watershed's roughly 1.5 million acres of wetlands are critical to restoring the Chesapeake Bay and its tributaries across 6 states in the District of Columbia. Wetlands are essential to water quality. They trap pollutants that are running off farmlands, suburban parking lots, and city streets before they can reach the 111,000 miles of local streams, creeks, and rivers that empty into the bay. Entering the Atlantic hurricane season, it's worth noting that wetlands also protect coastal and flood-prone communities by absorbing storm surges and floodwaters like sponges. Wetlands also mitigate slow-onset climate change effects like sea level rise and sunny day flooding that threatens lives, businesses, and properties in waterfront cities like Annapolis. Maryland, Pennsylvania, and Virginia have state regulations that could offer backstop coverage for wetlands that are adjacent to but not adjoining the bay and its covered tributaries. EPA can no longer protect. But we should not be abrogating this shared responsibility just to our states. Nationwide, more than 111 million acres of wetlands and the ecosystem services they provide are estimated to face the essential threat from the loss of federal protection. Justice Kagan also wrote a brief opinion on her own, joined by Justices Sotomayor and Jackson, in which she criticized what she characterized as the court's appointment of itself as the national decision maker on environmental policy. In her view, which I share, Congress deliberately drafted the Clean Water Act with a broad reach to address a problem of crisis proportion. Although the majority disagrees with that decision, she wrote, it cannot rewrite Congress's plain instructions because they go further than the court would like. But this is precisely what the majority did here, she concluded, just as it did last year when it curtailed the EPA's authority to regulate greenhouse gas emissions from power plants. Second is the latest in an alarming series of rulings to undercut the agency's mission to protect human health and the environment. This one happens to hit especially close to the statutory home of the Chesapeake Bay Program Partnership. For now, to assert jurisdiction over an adjacent wetlands under the Clean Water Act, a party must establish first that the adjacent body of water constitutes waters of the U.S., relatively permanent body of water connected to traditional interstate navigable waters, and second, that the wetlands has a continuous surface connection with that water, making it difficult to determine whether the water ends and the water wetlands begins. This arbitrary new definition strikes at the heart of the Chesapeake Bay Program, science-based decision-making. Moreover, as Justice Kavanaugh notes, the court's new test is sufficiently novel and vague that it will create precisely the kind of regulatory uncertainty that the majority roundly criticized. The decision muddies the waters for a clear, workable waters of the U.S. definition after years of uncertainty. The rule of the final revised definition of waters of the United States rule the EPA and U.S. Army Corps announced in December established a clear and reasonable definition. The common sense approach by the EPA must now be recognizes that pollution upstream can have downstream impacts. So we must protect the system to safeguard downstream communities and our environment. The rule, this opinion invites opponents to challenge, also maintain long-standing Clean Water Act permanent exemptions for routine farming and ranching activities. Basically complied to what we thought the rule was before the Supreme Court decisions almost a decade ago. In addition to the indirect costs of regulatory uncertainty, the loss of clean water protections will have significant economic consequences for outdoor recreation, which supports $788 billion in consumer spending and more than 5 million jobs in the United States annually. Wetlands do not just provide habitat for wildlife and trout and fisheries that enhance outdoor recreational opportunities. They also clean water for farmers that drive our economy through the production of food. In order to protect our resources in our new reality, we must enforce the federal authorities left that protect clean water, support states strengthening their own laws and regulations, and take action to restore protections. In addition, clean water infrastructure grants programs such as the Clean Water State Revolving Fund and the non-regulatory coastal habitat restoration programs like the Coastal Program offer resources to support states, tribes, and NGOs restoring wetlands in their own best interest. Water pollution has never respected political boundaries. Our constituents all rely on clean water for drinking, swimming, fishing, irrigation, and more. I urge my colleagues to consider the seriousness of this setback and let us work together to mitigate the damage of this decision. With that, Mr. President, I would suggest the absence of a quorum.